Here is your WESN News on the hour. I'm Naomi Maknish. Thanks for joining us. Here are the headlines. Wesn calls for ban on violent and bad girl music. Imbert welcomes Moody's stable outlook. Opposition questions economic progress. 2 men arrested in separate traffic offences and appear in court. Bail granted for firefighter on rape charge. Now for the details. Progressive Democratic Patriots leader Wesn has vowed to ban music that glorifies violence or promotes negative behavior if given the opportunity to lead Trinidad and Tobago. Speaking at the funeral of 21-year-old Zachary Lindo, Tobago's 26th murder victim for 2024, Duke said the country is losing its youth to gun violence and harmful culture influences. He also criticized bad girl music, saying it degrades women and contributes to societal decay. Duke called for a collective effort to address these issues and save the nation's future generations. Finance Minister Colum Imbert has welcomed Moody's decision to maintain a stable outlook for Trinidad and Tobago's economy, citing government efforts in revenue diversification and growth in the non-energy sector. Imbert highlighted that the stable outlook reflects positive medium-term prospects for the country. However, opposition MP Devendranath Tanku criticized the finance minister, noting that Moody's report showed no significant improvement in the nation's economy. Moody's also noted the fiscal challenges posed by lower energy revenues, but acknowledged the country's buffers, including the Heritage and Stabilization Fund. The economy's stability is further supported by continued investments in oil and gas projects. 2 men aged 44 and 46 from Moruga and Princestown were arrested on January 7th and 8th during separate traffic exercises coordinated by the Princestown Municipal Police. Nigel Braxton, 46, was arrested for driving while disqualified and without a valid insurance certificate, while Anthony Pear, 44, faced similar charges. Both men were granted $10,000 bail and will appear before a magistrate on January 10th. The operations, which involved stop and searches and penalty notices, were incident-free. Bail was granted to a 42-year-old industrial firefighter from southwest Trinidad who was charged with the 2019 rape of a female minor. Kareem David faced Master Delisha Bethelmi in the Criminal High Court on January 8th and was placed on $90,000 surety bail. As conditions of the bail, the accused must stay at least 100 feet away from the victim and not have any communication whatsoever with her. Police contend that on the morning of November 18, 2019, the man forced his way into a house and raped the 13-year-old child. The same day, a report was made to the police. On January 7th, officers from the Special Victims Department of the Southwestern Division arrested the industrial firefighter in the South Oropouche district. Superintendent Powder ASPCs Cicharan and Francis, Inspector Jacob and Sergeants Taylor and Thompson led the investigations. WPC Myers charged David with 1 count of sexual penetration. The case was adjourned to March 7th. Well, that's news to the hour on WESN. I'm Naomi Maknish. Thanks for watching. Between the Bank and the Gutter, a novel about street dwellers in Port of Spain. This is a book to make you both laugh and cry. Above all, it takes you to that special space that only street dwellers know. In this moving and riveting human interest story, Harry journeys from insanity to sanity while living on the streets of Port of Spain. Now available at Metropolitan Books, 12 Aripita Avenue, Woodbrook. Paper-based bookshop, 14 Alcazar Street, Woodbrook. WESN, 30A Gattaca Street, Woodbrook. And the home store branches located at Barataria, Shogunas, and East Gates Mall. Autographed copies now available on request. Also available from author Louis Lee Singh. I Used to Live in Heaven, Letters to My Granddaughters, Local Government in Trinidad, Conspiracy Against the People, and Closer to the Church.
FanZone, your reliable, authentic supplier, has just gotten better. You can now visit our website www.fanzonett.com for your authentic wear and collectibles. The only place where you can use both your Visa debit and credit cards. Visit our website fanzonett.com to make your purchase today.
Having trouble Christmas shopping? Check out the Kids Shop today. For all your officially licensed kid character merchandise, we carry characters such as Disney Princess, Frozen, Spider-Man, Paw Patrol, Sonic, My Little Pony, and much more. Call or visit us on Facebook or Instagram. Nationwide delivery available. The Kids Shop, for all your licensed kids character merchandise.
Well, Happy New Year to everyone. Thanks for staying with us here at WESN. I'm Andy Johnson. Good to see you on this bright morning today. A new day, a new year in Trinidad and Tobago. Well, let's tell you what we're talking about. It's something that I chose to call the presumption of innocence. It has to do with the conduct of trials of people who are accused of committing the high crime of murder and any form of taking a life. We will go internationally and then come back home and look at some issues that I'll present themselves for consideration under this matter. Our guest is our good friend here around this channel, Mr. Farid Ali. I want to start. Very good to see you and Happy New Year.
Happy New Year to you. It's always good to see you.
All right, so we want to call it the presumption of innocence. And I tell you the term came about in watching the news one night a couple of weeks ago about this man in the United States who shot and killed the man who is a big figure in one of the major health organizations in the United States. And in the commentary that I was hearing on TV, watching it, they are talking about how important the whole question of the presumption of innocence is in a case as horrid as it could be. My thing is that you saw that there was a video of the man coming out of somewhere and shooting at the health company official, shot him in his back and killed him. But the discussion is that. So you see that, but that is not where it begins or where it ends. And I come locally during the course of the discussion. But the whole question of the presumption of innocence, and if guilt cannot be proven, somebody walks free. And we've seen how it happens in a lot of cases. Let's talk about the philosophy of that. Why is it that, so the accused has the benefit of the doubt until it can be proven that he or she, in fact, committed the offense, regardless of what you see, outside of the court? It has to be established as a legal principle in the court.
All right, let's contextualize this in the context of Trinidad and Tobago.
All right.
It's the same, the law is philosophically the same thing in Trinidad as it is in the US, as it is in Europe. In every democratic country where we uphold the rule of law and we recognize that the rule of law prevails, what that means in reality is that regardless of one's race, color, religion, origin, sex, one has certain freedoms and fundamental rights, and one of those rights are the presumption of innocence. We must recognize that that presumption of innocence, that presumption is born out of, in the context of Trinidad and Tobago, our Section 4A right, which is our right to life, liberty, security of person, enjoyment of property. So let me tie it in now. If it is we have the right to life, liberty, security of person, and enjoyment of property, it means to say every citizen, including the vagrant lying on the street in Port of Spain, and the CEO of a company in America, or any high-profile politician, lawyer, doctor, whoever, these individuals sit on a level playing field in the eyes of the law. Nobody has a right that is superior to the other. So your right to life is on equal platform with my right to life, and our right to life is on equal platform with a bum, a vagrant, a homeless person. Now, if there is an accusation against either one of us on any level or in any stratosphere of the society, we are all innocent until the court litigates the matter and evidence is presented in the courtroom and it is proven beyond reasonable doubt that there is no question that you are guilty as charged. So the presumption of innocence prevails, and you are entitled to due process whilst that presumption of innocence prevails. And that due process is you have the right to be informed as to what the allegation against you is. So if it's an allegation of murder, you're informed, you're brought to court, the magistrate or the judge or the district court judge explains to you what is the allegation. And then when you are explained what the allegation is, you are remanded to the nation's prison, and you're given an opportunity to hire a defense attorney, or one will be provided to you if it is you can't afford one. And that attorney and you will sit in private and examine the disclosed material handed over by the prosecution to you. And that disclosed material is the evidence that the police would have gathered during the course of an investigation. So let us say, Mr. Johnson, you are arrested in the morning. You're arrested and they're told that something happened on Gattaca Street, and they believe that you fit the description of the individual who committed the crime. In this case, if we were to zoom out a bit and we get to that the situation in Manhattan, Luigi Mangione walked up to the chief executive, Brian Thompson, and shot him in the back in Manhattan. There may be video footage right there in Manhattan. It's very likely, developed country like that, video footage on the streets capturing Luigi Mangione walking towards Brian Thompson and extending his hand and shooting him in the back.
Yeah, as a matter of fact, that was established. There's footage establishing that. Right.
Now, the footage may establish that, but the man Luigi Mangione, we don't know if the footage. I'm just saying. I'm being a defense attorney here, the devil's advocate.
Right.
Remember, his job is to try to do the best for his client, and in the face of the worst, get the best result, which is two different things, right? At the end of the day, let us say the evidence against the young man is of such where, yes, he's seen shooting, but you don't know what his state of mind was. He had an obsession with United Health Group and United Healthcare in America.
Yes.
And he, for some obvious reasons, views Brian Thompson as the author of some of the confusion that was taking place in the healthcare system and some of the suffering that individuals or individual receivers of that healthcare were debilitating under. In other words, whatever his grouse is, he took it out on Brian Thompson. In doing that, what it meant is that his mind may have been impacted and he may have been committing the act of murder sufficiently provoked by things that he, in his perception, suffered as a result of a United Healthcare or United Health Group. In other words, murder is the intention to kill. Murder is the intention to cause grievous bodily harm and serious bodily harm. If it is his mind, his ability to reason was sufficiently affected, he was provoked, he may not have that may be a mitigating factor. This is not a contract killing. This is not an act of terrorism where the violence that was inflicted was not stimulated by something done or perceived to be done by Brian Thompson. If that is indeed the case, then part of and tied into the presumption of innocence is that he may not be entirely and unequivocally responsible for his actions, because his mind may have been sufficiently impacted and affected that he was not author of the things that he did. In other words, he does have control over mind and matter. In that moment, you lose control. You lose it, as they say in Trinidad. In other words, your intention could be a malicious intention. The law is intending to go after individuals who have a malicious intent to kill. But what about those of us who have a damaged mind born out of a bad experience, and we react in a moment of madness? Should that individual be treated in the same way? In other words, the law makes allowances for persons who may lack the malicious intent, but who may have been inspired and provoked by the actions of perhaps the victim.
Is that what you call? Is that what is called in the trade diminished capacity or diminished responsibility?
That is exactly that. Now, the beauty with diminished capacity and diminished responsibility in the eyes of the law is that the condition can't be conveniently used. In other words, I can't say, because I could easily say, well, I was pissed off that morning. I had no breakfast, no coffee. I was irritable. And when it is I saw that man, I reacted in the way that I did. That in itself is an unnatural example. You have to prove that there was a clinical condition that was impacting you. So let us say you have some sort of mental illness, schizophrenia, that you labor under, and you haven't been taking your medication, or you are bipolar, or you have a social situation that has been impacting your mind on such a level that it can be proven clinically that you were laboring under a condition that clinically impacted your ability to process and to think clearly. So in other words, the way you acted in that moment was impulsive, given that you didn't have control over your mind and your actions. So anybody listening out there, you can't just drink rum and say, well, I was drunk, and then commit a crime and rely on that as a defense. You can't say, well, you were having a bad week, or you were laid off, and therefore, having lost your job, you were depressed. It's not something as simple as saying you're depressed. There must be some clinically diagnosed condition that would have triggered, and that ought to have triggered the circumstance in order for you to be relying on it successfully. The law removed, before provocation was a partial defense for murder. That has since been removed. You must show that not just you were provoked, you should exercise more restraint. So when the law used to be that, words said by an individual and actions committed by an individual, perhaps your victim, inspired you to react in such a way, you could no longer rely on that provocation defense. You have to show that not only was I provoked, but I was laboring under an innate condition that his actions or his words and the marriage of those caused me not to be in control of myself. So it has to be a little more in-depth, a little more solid. Now, let's get back to the presumption of innocence.
Yeah.
In the eyes of the law, when it is you come to court, you come to court on an allegation. You come to court in terms of the police have conducted an investigation. They have CCTV footage of you walking up to a man in Manhattan, extending your arm with a firearm in it, and you pull the trigger and the man hit the ground. They check the man, he's dead. That would be what we call real evidence. CCTV footage, cameras would have captured you committing that act. But there are other forms of evidence. There are also eyewitness evidence. So there were persons who may have been around Mr. Brian Thompson, and they would have turned around and witnessed him hitting the ground. They would have witnessed the incident taking place, and they would have seen Luigi Mangione walking away, or he may have been held in the moment. So in other words, there is clear identification evidence that I saw it with my naked eye.
Yeah,
That is
and in
that's
fact,
what you call an IC witness.
right, and in
So
fact, he had
apart from the
been
CCTV,
tracking the
there's
man
IC
for
witness.
some time. How do you factor that? He had been tracking the man from city to city for a period before he got the opportunity to shoot him on that day on the subway.
Right. Well, if I was to understand you clearly, if it is you've been tracking the man, meaning he has been following Brian Thompson and seems to have been seeking the ideal moment to commit or to engage him, right? That in itself, if it is there is evidence to the effect that he has been following him, because we may say he has been following him, they have to be able to
establish that.
Establish evidence that the trips he was making and the journeys he was making and the places he was going to, if coincidentally every time Mr. Thompson turned up in a place, he happened to be in the community, he may be able to explain that in a different way. But again, what if it is he was confiding in a friend? Sometimes these fellas say, they tell a friend that, I'll deal with this man. So, but that is still evidence. To piece that into the equation, let us say that there is evidence that he has been following this man over protracted and consecutive period of time. Then that and all may come through another witness. So you have the CCTV footage that captures him on camera. You have the eyewitnesses that were in Manhattan, in and around Mr. Thompson, that would have captained, that would have witnessed the incident. Then you would have you may have had fingerprints where his fingerprint is on the weapon. So they may be able to lift prints from the gun. We don't know if there was any physical interaction before and after, or we don't know if it is he visited the scene and did he surveyed that area where Mr. Thompson is supposed to enter before, and there's footage of him being in the building, and then he exited and then reapproached the individual, like what happened to John Lennon back in 1980 when somebody approached him in New York on the streets.
Yes.
Sometimes these guys and them they plan their thing and they check, they work out how they're going to do this. In other words, it's a carefully convoluted, mapped out plot.
Yeah, but if it gets established that he may not have been of sound mind when he pulled the trigger, that works in his favor.
It always works in your favor. It always pays to be, slightly off upstairs here. It helps. Now, bear this in mind, there is what you call clinical mental illness, and there is what you call a man may be legally sane, but he may be clinically insane.
Yeah.
Let me say that. Let me explain that in lay terms.
Yeah.
I cannot use my bipolar diagnosis to say, well, I have my papers, I bipolar, I diagnose bipolar, why I being treated for schizophrenia, and I take my medication, or I have a history of mental illness in my family. My grandfather was a madman, and I demonstrate little tweaks and little traits, and once I take my medication, I cool, and then I say, you know what? Because of my condition, I will murder somebody and use that as a defense. You can't. In other words, you cannot use your condition as a defense.
Yeah, but it's
you
been
must
part,
be,
it's
if
been
you're
part
raising
of,
it, you must be actually showing where there's a direct correlationship between the crime you commit,
while I'm
or
chuckling,
the act you commit, and
yeah.
the condition that you're laboring under.
Because why I'm chuckling is because in growing up, I used to hear that term. Somebody will tell another person, do interfere, he have mad papers already.
Exactly. So one could be legally sane once it is proven that that is why it is when an accused person comes before the court. The defense attorney may say, well, I would like my client to be assessed at the St. Anne's Medical Facility because he has a history of mental illness. The psychiatrist at the St. Anne's Hospital would sit with the individual and observe them over a period of 14 days. And they detain and diagnose and they clinically assess the individual to determine whether their condition was a condition that played an active part in their course of action. So one having mad people papers is one thing. but one can't use the papers conveniently. So in situations where a man has a clinically diagnosed condition, he cannot use that as a forum or as a platform to commit crimes.
All right.
Now,
and there's a distinction between being found not guilty and being thought of as innocent, because the conduct of the trial will determine guilt or absence of guilt. But that doesn't necessarily translate into innocence. And a lot of people, sometimes some of us confuse that. Because somebody got off on a charge, people tend to go away and say, well, he was innocent of that. You don't get found innocent. You're found either guilty or not guilty. Make that distinction for people who tend to struggle with that sometimes.
right. What ties a man to a crime is nothing less than the investigative material that the police would have garnered when they were conducting their investigation. In other words, evidence is what determines innocence or guilt. Evidence determines a guilty or not guilty. So if it is the evidence as presented in a trial doesn't speak to a man committing a crime, in other words, the police did a very good job, or the police did a very poor job. A very good job may result in a guilty plea. In him being determined guilty by a jury.
Yes.
But a poor job, meaning the evidence is presented poorly, may result in a not guilty verdict. In other words, there's a kaleidoscopic distinction between a verdict of guilty or a verdict of not guilty and the presumption of innocence. In other words, one is presumed innocent until there is a verdict of guilt or not guilty.
Until proven guilty.
So, exactly. So the presumption of innocence really has to do with the fact that the due process that a man is entitled to and the equality of treatment before the law allows that he stand in the dock and he listens to all the evidence as presented by the prosecution, and his defense attorney is given the opportunity to challenge the so-called identification evidence, whether the lighting conditions in which he was seen, the distance between him and the individual who identified him, the descriptive details presented by the IC witness, which is the person who identified him, meets his description, and whether the conditions in which he was seen, meaning if he was seen in darkness or in light, whether the individual is sufficiently certain that that was the man he saw, meaning he saw the correct man. He didn't just see a bald man with glasses and a beard with sideburns. That he saw that in other words, the courtroom process, the litigation process allows the jury to hear the evidence and allows the prosecution to present its case and to allow the defense attorney to cast doubt on the evidence presented by the state and by the prosecution, and to allow the judge to evaluate the law and put the responsibility in the hands of the jury, given the facts that they've heard, and tell them that sometimes you may have an honest witness, but there are some witnesses that are honestly mistaken. So in other words, they may think and believe what they saw was Andy Johnson, a man of dark complexion, medium build, of a certain age bracket, but there are several individuals who fit that sort of description. In other words, the description is generic. The judge may say, bear in mind that the evidence presented in the courtroom of identification is a generic description. It never said something like the man has a scar over his right eyebrow, or he has a cut on the tip of his nose, or he's missing a front tooth. Those are not generic descriptions. Those are very specific things. He has a tattoo, a teardrop tattoo about over his left eye, that sort of thing. So
right. There are two matters.
The presumption of innocence prevails, throughout the trial process.
Yeah.
It's at the conclusion of the prosecution's case and at the conclusion of the cross-examination by the defense attorney. And when everybody sounds, the first person to speak in a courtroom, meaning the prosecutor, he sounds like even though he has an airtight case, is when the defense attorney starts challenging the video evidence, starts challenging the IC evidence, starts challenging the scientific evidence, which is the fingerprint, the DNA evidence, then we may be in a position where, you know, the jury begins to see the evidence in a different light. They see the panoramic picture, they see the whole story. And then they may say, you know what, there's some merit in what is being said, you know. Though he's presumed innocent, but the jury isn't satisfied that the evidence presented through the police witnesses and the civilian witnesses by the prosecution has sufficiently satisfied us that the man we have here is indeed the man. So the beauty with the law is, under Section 5, subsection 2F of the Trinidad and Tobago's Constitution, a man is entitled to the presumption of innocence until proven guilty according to law, and to a fair and public hearing. So one is entitled to, yes, you are presumed innocent, but the same way that you have the right to life, the man that is dead has the right to life too, and he has lost his life. So you must have a trial, and in the trial must be a fair and public hearing, and you must allow the person arrested to be presumed innocent, and that presumption prevails throughout the length of the trial process.
All right.
Once the evidence is heard and the prosecution lays its case and the defense has an opportunity to defend the evidence presented against its client, then the jury makes a decision, and the presumption of innocence at that stage, it subsists up to that moment when the jury has a decision to make whether they say guilty or not guilty. We have the view that they have the correct man, that this man is guilty, and at that point,
right, yeah,
the presumption of innocence collapses because a case has been proven, and the jury says, well, you know, our view is he's guilty.
We're not going to have time, but I wanted to just raise the two issues which are local, you know, for examination under the principle we're talking about here. One was the abduction and disappearance of the lady called Vindra Naipaul Kuhlman, and the other was the killing of the people in Moruga, was it, in which 7 police officers were seen as having committed that crime. In both cases, Israel Khan played a major role. One, he was the prosecutor, and the other one, he was the defense attorney. In the defense attorney, a job with the incident in Moruga, or wherever it was, all 7 of the police officers got off. In the case where he was the prosecutor with the people, 9 of them, I think it was, who were accused of taking the lady and taking her out, they were found not guilty. So in both cases, you had not guilty verdicts in which these matters went out they were there in the public imagination for a long time. So on both these cases, there's those people who would say, well, justice wasn't served because somebody would have had to have been involved. 9 people, I think, were arrested and charged in the Vindra Naipaul Kuhlman case, and then the 7 police officers. In both cases, they were found not guilty.
Right. Innocent people, the fact that the jury has determined that you're not guilty of an offense doesn't speak to the fact that you may not have committed the crime. It means to say that the defense attorney was successfully able to challenge the evidence as presented by the police sufficiently that the jury did not feel convinced that the man that they have in the dock, or the man that was charged, was indeed the man responsible for the crime. So, in other words, you may have an innocent man having been found guilty in a courtroom and he sentenced to hang, and you may have guilty people having been found to be innocent of the crime, meaning that the person's responsible, they may be responsible for the death, but because the evidence was so poorly laid, they were determined to be not guilty by the court. In other words, innocent or guilty or not guilty, is determined by the evidence, and if the evidence is poor evidence, you have a better chance of walking away. Now, you're making specific reference to the Vindra Kuhlman matter.
Yes.
We can't go too deeply into the evidence in that because there are other persons who have to answer to the charge in that. Persons walked away in that, and there are other persons that has to face another trial. But what I could say is this. When we examine the evidence in these matters, there may have been a not guilty verdict against some in the number of persons that were arrested and brought before the court. So one of them would have walked at a no-case submission, meaning that at the end of the prosecution laying its case, it is found on a balance of probabilities, or it is determined that the evidence against a particular individual may not have been sufficient to connect him to the crime.
Yeah.
What happens? And then there would have been situations where the case went a little further, where the court is of the view that the person may have some involvement, but though he has an involvement, he may not have been aware that there was a murderous intent by the actions of the persons he was involved with. Let me put it this way. When we have a crime of joint enterprise, meaning several persons come together to commit a crime, they coming together may not have been. And I'm just saying they here in the context of, we're dealing with a general example, right? Joint enterprise. I don't want to zero in on Pullman and what happened in that in particular. But it's the same matrix of joint enterprise.
It's a principle.
You may find that an individual was he provided support to the person who pulled the trigger or the person who actually committed the act. Let us say it was a breakneck situation. Let us say it's a gunshot situation. If it is, I present intelligence that a person is working today between the hours of 9 to 5, and the person is tends to leave the business place and get to their vehicle between 5 and 5:15. Or that is what we call providing intelligence before the commission of offense. In other words, you would have been complicit in providing information before.
Okay, we're running out of time. I want to ask you that let's come and do a second edition of this discussion. Right?
Of course.
Okay.
Of course.
Thank you very much.
It's always great to be here. Thank you for your time.
Yes, thank you
Enjoy
very
it.
much, Farid Ali. Well, thanks for watching. This has been 10 questions on this day. We will continue with this discussion as we go forward, but thanks for watching. I'm Andy Johnson. Stay right here with us at WESN.
WESN